Welcome to the next installment of Contract Conversations. This is a series of bi-weekly, bite-sized webinars that we're holding to discuss key contractual issues which people operating English law contracts need to be aware of. Today we're going to be discussing how to go about terminating contracts safely, particularly in the context of supply contracts, given the recent enactment of new restrictions which are set out in the Corporate Insolvency and Governance Act 2020. I'm Eric France, a commercial disputes partner based in the London office of Mills & Reeve, and today I'm joined by Lino de Lorenzo.
Hi, I'm Lino. I'm a principal associate in the commercial disputes and insolvency teams at Mills & Reeve, and I'm based in our Cambridge office.
There is, as always, a Q&A function, a question function at the bottom of your screen. So please do use that to type in any questions you have, either during our presentation or at the end. And we'll try to deal with as many of your questions as we can at the end of this short webinar. Okay, so first of all, why terminate a contract? Termination can be attractive to parties for a number of reasons who are looking to bring a contract to an end. Some of the big advantages include that it's a self-help remedy. So unlike other remedies, you don't need to go to the time and expense of obtaining an order from the court in order to terminate a contract. You can just send a termination notice. So compared to some other remedies that you might be entitled to when the other side is not keeping their side of the bargain, termination has that big advantage. If you do successfully terminate a contract, then you will be relieved of all of your future obligations under that contract from the date that the contract is terminated. And this remedy of termination can be combined with other remedies as well, including damages claims. So you can both terminate a contract and sue the other side for damages for their breaches of contract. So for all of those reasons, termination is often an attractive option. But what are the risks? Well, the big risk that comes with termination is the risk of litigation. Because if you wrongly terminate a contract, then your purported attempt to terminate the contract is treated as a renunciation by you of the contract and your commitments, your commitment to honor the contract, and that renunciation gives the other side the right to themselves terminate the contract by relying on your unlawful purported attempt to terminate the contract. That gives the other side the right under the common law to elect to terminate the contract themselves, and potentially to also sue you for damages for your wrongful termination, including what are known as loss of bargain damages. And these are damages to compensate for the contract coming to an end before it's term, before when it was expected to come to an end. And those kinds of damages, loss of bargain damages, can be very substantial. They can include things like loss of profits, and they may even include amounts that, for example, a party has become liable to pay to its subcontractors as a consequence of the head contract coming to an end early. So there can be significant risks of litigation and liability for damages if you try to terminate a contract, but do so in a way which is invalid and isn't lawfully justified. So Lino is now going to explain some new restrictions which apply in certain circumstances when a party is trying to terminate a supply contract.
Thank you, Eric. Well, earlier this year, the Corporate Insolvency and Governance Act brought in some of the widest reaching reforms we've had in insolvency laws in the UK for the last 20 years. That did a number of things. It introduced limits on the ability of creditors to use insolvency proceedings to collect in their debts. It introduced a number of different types of insolvency proceedings which we didn't have before. And for the first time, it also placed limits on the ability to terminate certain contracts after a company had entered into an insolvency process. Now, we're here to talk about the third, but the fact that there are limits on the ability of creditors, for instance, to use insolvency proceedings may well be one reason why counterparties might be thinking quite carefully about whether to bring contracts to an end, because your counterparty is in financial distress. Many contracts contain a right to terminate for insolvency. Insolvency is usually a defined term in many agreements. And if the definition is met, then the contract can usually be terminated just by serving a written notice. Now, up until the Act came into force, English law is operated on the basis of freedom of contract. You can basically agree what it is that you like. And so it was quite this is the first time we've seen, in relation to termination in particular, there are now statutory restrictions on your ability to be able to exercise the right. The way the Act works is that if you're a supplier for a contract of goods and services, you as the supplier will not be able to terminate the agreement just because the company's entered into an insolvency process. And not only that, if you had a right to terminate that existed before the company goes into an insolvency process, that right to terminate is also suspended. So take this as an example. If the company was in breach of contract because it hadn't paid a sum that was due on time, or repeatedly hadn't paid a sum that was due on time, and that gave rise to a termination event, but you wanted to see whether or not you could sort of patch your differences up, but the company then enters into an insolvency process in the meantime, if you hadn't already exercised your termination right by that point, the termination right can't be exercised anymore. Now, what that can mean is, effectively, because the right is suspended during the insolvency process, it can often mean your right to terminate is effectively rendered meaningless. Whether that's a right to terminate for breach because it was already a pre-existing breach, or whether that's because the company's entered into an insolvency process. Now, you can get around this because contracts can still be terminated if it's by agreement. You can either agree with the company, or if it's gone into administration or liquidation, you can agree that with the administrator or liquidator. But if they don't agree that, then what you would need to do is ask the court for permission. And in order to do that, if you're the supplier, you need to be able to show that the not being allowed to terminate would cause you hardship. What you can't do is try and force or use the opportunity to force new terms and conditions on the company as a condition of you continuing to supply. As well as restricting your ability to terminate, one thing the Act also does is prevent you from relying or using or acting in a ransom way to make sure that the company can still be provided with those services in the meantime. There are a few temporary reprieves for small suppliers. Originally, they were in place only until the end of September, but they've now been extended until the 31st of March 2021. And if you're a small supplier, if you fit one of these 2 out of 3 criteria, so if you have turnover of not more than 10.2 million, or you've got a balance sheet of 5.1 million or less, or 50 or less employees, then these restrictions don't currently apply to you. They will start applying to you from April next year, but for the time being, that they won't. Now, the whole point of this was that this is intended to try and promote a rescue culture. So the purpose was to try and protect the company that had gone into an insolvency process, and try and make sure that it could still retain the benefit of these contracts, can still get supplies, it's still in a position to be able to perform, and hopefully preserve the value of the business and jobs in the meantime. So whilst we don't yet have any reported decisions about what would actually happen if somebody purported to terminate in breach of these restrictions, it seems quite likely that what the court might do is intervene, possibly with an order for an injunction or an order for what's known as specific performance, forcing you to carry on supplying if you were refusing to do so, because otherwise it might permanently damage the prospects of the company being rescued. For all of these reasons, it's really more important than it ever has been to try and understand what termination rights you have got, and how and when to exercise them if you are going to be dealing with a company that you think might be in financial distress. There are some key issues to think about, such as, is your contract caught by these restrictions at all? How do you find out if your counterparty is in financial distress, and what should you do about it? Are there any other termination rights you might have? Because if they are, maybe you should be thinking about exercising them if you're worried. Are you covered by the exemption as a small supplier, which I've just mentioned? But it's also critical to make sure that if you do terminate, you get the notice right. So I'm going to hand back to Eric now, so we're going to talk through some practical tips that you might want to, that you really need to be thinking about.
Okay, so here are some practical tips. The first few of these apply sort of generally whenever you're terminating a contract. The second half of that list is aimed more at some of the points Lino's been raising about supply contracts and the restrictions introduced by this new act. But starting at the top there, store up multiple breaches. It's always a good idea, not to rush a decision to terminate a contract. If you can, think about delaying things for a while, if that will allow you to build up more and more arguments that support your right to terminate the contract, more and more breaches that you can point to from the other side, which might entitle you to terminate the contract, because that will strengthen your argument. It is possible to rely on this case law to the effect that it's possible to rely on put forward multiple arguments as to why cumulative arguments as to why you're entitled to terminate a contract. The second point there is, and this is really a key one, always take legal advice before you terminate a contract, not afterwards. Termination is quite a complicated area, and it's just got more complicated as a result of the enactment of this new act. And it's always best to consider all of your options and take legal advice before you terminate a contract. Don't make the mistake I've seen many times of terminating a contract and just taking the position that, well, I'll see how the other side react and whether or not they kick up a fuss about it or not. And if they do, then I'll get legal advice then. That's too late. It's too late once the other side have kicked up a fuss, because at that point, the die has largely been cast. There's only so much your lawyers will be able to do for you. If there is litigation, the lawyers won't be able to shape the outcome of that in any way. It's far better to get lawyers involved before you terminate a contract than afterwards. Thirdly, draft your termination notice carefully. If the lawfulness of your decision to terminate a contract is challenged, then lawyers could be arguing about what you said in that termination notice for the next couple of years, potentially. It'll be the central document in any litigation case relating to the termination of that contract. So it pays to get help from lawyers to help you draft that termination notice and put your right to terminate in the most favorable light possible. So the next point there, kitchen sink the termination notice. So if you do have multiple grounds for terminating the contract, always include as many of those grounds as possible as you can in your termination notice. Throw the kitchen sink at it. The reason for that is, even if the court doesn't accept that all of the breaches that you put in your termination notice are breaches, or that they rise to the level required in order to allow you to terminate the contract, it's always best to keep your options open as far as you can and have as many breaches as possible put into that termination notice. You can, in fact, still rely on breaches that are not in your termination notice and as justifying your decision to terminate the contract. But it can be less credible to say that the breach was sufficient to allow you to terminate if you didn't even decide to include it in your termination notice at the time. So it's always better to include more rather than less in the termination notice. Over to you, Lino.
Okay, a few things to think about on the insolvency side. First of all, is the contract that you're dealing with caught by these restrictions or not? This is concerned with supply contracts, and the restrictions are on suppliers, not the other way around. So this is not a situation where the company can simply turn around and terminate, or if you are the customer, and it just so happens that your supplier has become insolvent. It doesn't work those restrictions don't work that way around. But not all contracts are caught. So most contracts that there are a list of types of contracts in the Act which have been excluded, although they're mostly relating to insurance or finance. there has been some question mark about what happens if you've got supply contracts where you've got a mix of contracts that are supply of goods and services, and or there's a financial part of it. And it would appear, based on the notes in the Act, that it may be that only parts of that contract can be terminated. So it's quite important to bottom out whether you are caught by these restrictions or not. Eric has also talked about kitchen sinking the termination notice, and I would really underline this here if you're thinking about terminating for an insolvency reason. The reason for this is because if you terminate for an insolvency reason, you're not actually terminating for breach at all. So if you do decide to terminate for this reason, it's really critical to get the notice right, and to check what the contract says. If you terminate for this reason, terminating is for an insolvency reason is not the same as terminating for breach. And so what that means is that it's possible that you could lose what we call any loss of bargain damages claim you might have if you're terminating a long-term contract. And it might be that you lose the right simply by stating in the termination notice that that's the reason that you're terminating for the insolvency event, and not because there's been some other breach. And there is quite a good example of how this can backfire, which is some time ago, EE terminated a contract that they had with Phones for You when it went into administration, and the administration was the reason that they gave for terminating. The reason that came back to bite them is because sometime later, the administrators for Phones for You chased for some quite substantial payments from EE, which they hadn't paid. And what EE then tried to do is to argue that Phones for You had been in breach, and they were trying to offset the claims against each other. But the problem is that they hadn't, although they purported to try and reserve various rights in the termination notice, they hadn't actually given that as the reason to terminate. And so the court actually held that they'd lost the right altogether. So very, very important just to keep that in mind. And another reason why kitchen sinking the termination notice I would really reinforce. You should be keeping an eye on whether your counterparty is in financial distress. If you're worried about it, why are you worried about it? Is it because they're slow in paying, or are you concerned about something else? What you need to do here is actually check what the definition of insolvency is in the agreement, which might make you think that a right to terminate potentially might arise. The restrictions in the Act are broadly in line with the company having already entered a formal insolvency procedure, such as a company voluntary arrangement, an administration, liquidation, or a moratorium, which is a new form of procedure that's in place. But they generally don't capture a right to terminate if you take steps leading up to that. And quite a lot of contracts do have a right to terminate for insolvency reasons, which just fall slightly short of going into a formal insolvency process. So you should check actually whether that, whether there's any information that might aid you in making a decision about whether some of those rights might be triggered. In some cases, you can find out whether or not a company's entered a formal insolvency proceeding by making a phone call to what's known as the Central Index of Winding Up Petitions, and there is a phone number to call to check whether or not any proceedings have actually commenced. But certain things you simply won't know. So if the company's, for instance, to cease trading, or it's taking preparatory steps, or it's called meetings with creditors to consider proposals, for instance, you may not necessarily know whether that's happened without actually asking them, and they've got no obligation, of course, to tell you whether that's happened. But there is no better solution to this other than just to keep an eye on the red flags that you might have. And if you're a supplier, you would expect that the obvious red flag would be slow payments, and in particular sectors, a general slowing down of payments or cash flow difficulties in the long run. If you think you want to terminate, you do check if you fall within the small company exemption or not. And if you don't, well, what you're going to need to do is approach the company or administrator about whether they will agree to do that. Depending on how important the contract is to the insolvent company, the less likely it is that they will agree to that. But because I said earlier that the restriction only works one way, if you're a supplier in a chain, and the company above you is has its own forwarding on contract terminated, it may well be that the administrator or the company is prepared to agree. But if they don't agree, then a court application is going to be your only option if you do want to terminate. And of course, that brings me on to the last point, which is we've talked a lot about termination, but you don't have to terminate. So do you think through whether you actually really want to do that. in the option in the course of if it's termination for breach, obviously there may well be good reasons why you may want to do that. If you're terminating for an insolvency reason, you do need to think about weighing up the benefits of termination against the downside of it. And the reason I say that is because if the contract is if the administrator or liquidator or the company doesn't want the contract to come to an end, there's going to be some value to that. And the general rule is that in relation to goods and services that are supplied to an insolvent company, those sums for those goods moving forwards should be paid. And if they're not paid, you may well then, a right to terminate will then arise if they don't. So it is quite important just to think through whether actually it's worth the time, trouble and effort terminating, and thinking about whether actually in the short term at least, seeing all this through and getting them paid is worthwhile, especially bearing in mind that there's not a great deal you're going to be able to do about the fact that there are unpaid sums. The fact there are unpaid sums is not something you're likely to be able to change as a result of threatening to terminate.
Okay, so if we turn to questions, somebody's asked a question here. How does storing up multiple breaches work in terms of potentially waiving your rights if there is a delay? That is an excellent question. And the truth is that it is a bit of a balancing act. On the one hand, holding off before you make a decision to terminate and storing up as many possible breaches from the other side that you can rely upon gives you some extra safety and makes it harder for the other side to challenge your decision to terminate the contract and reduces your litigation risk. But on the other hand, if you delay making a decision to terminate and some of those breaches turn stale, then you could be said to have waived your rights to terminate as a result of that delay, in particular because particularly where you're exercising your rights to terminate under the common law, you need to make a clear election one way or another as to whether you are going to terminate what's called in the lingo, accept the breach and terminate the contract, or whether you're going to affirm the contract. If you delay too long, you could be taken to have affirmed the contract and lost your right to terminate. So it is a very real tension. What I normally say is that the best way to resolve that tension is rather than just ignoring breaches when they happen, even if you are storing them up, rather than saying nothing about those breaches, it's better to write a letter to the other side saying, we think you've just breached the contract and we reserve our rights to terminate in the future based on that breach. And if you create that paper trail, then that minimizes the risk of them being able to argue that you have waived your rights because of the delay and ultimately making the termination decision. So you need to be laying some sort of careful paper trail there, reserving your rights to terminate in the future. Okay, somebody else has asked, do the restrictions in the new Act apply to leases or licenses in respect of property? Lino, perhaps that one's better.
Yeah. Well, the short answer is they don't, because the restrictions only actually cover supply of goods and contracts for the supply of goods and services. Although in relation to leases, there's already a pre-existing restriction on terminating or forfeiting a lease, as it's called. And you would, if you wanted to forfeit a lease, you would still need to ask for permission or the agreements of the administrator to be able to do that. There's quite there is some established authorities about what you have to show if you want to get permission, if you want to be able to exercise a right of forfeiture. And generally speaking, you've got to be able to show that that it wouldn't have a detrimental effect on creditors to do so. Although obviously most of the time the reason that the administrator won't want you to forfeit a lease is because they need to trade from it. It does raise quite. I mean, the same doesn't apply to licenses. Licenses are not subject to the same restrictions, and so on the face of it, you could simply, if there's a termination right that arises in relation to a license, then there's no you could just terminate. Does highlight the distinction between leases and licenses and nothing else. Something else that this does, of course, do is that I've been asked quite a few times about whether, because of the restrictions that have come in, should we just be stripping out the right to terminate it for insolvency for the just because we can't do it? And I think my answer to that is no, you shouldn't, because invariably every lease contains a provision saying that an insolvency event is a forfeiture event as well. And to be honest, if you don't have the right to terminate for an insolvency event, you won't have the ability to terminate for that reason. You can still terminate if the circumstances permit, but you certainly won't be able to terminate if you don't have the right in the first place. So you do need that right in there, because as a matter of law, you are not entitled to terminate a contract for an insolvency reason if the contractual provision isn't there.
Okay, somebody else has asked, what happens if a customer terminates a supply contract in breach of the restrictions in the Act? Is the only risk that the customer might have to pay some compensation?
I'm not sure. No, I don't think that's. I don't think so, actually, because I think, as I said earlier, I think one of the policy reason behind these changes was to promote a rescue culture, and typically, if the company's in administration, and it's a trading business, what the administrators will probably be looking to do is to sell the business or to have some sort of accelerated sale, and it would be pretty damaging if the company was reliant on certain key contracts or supplies, and those were just simply terminated, and the administrator couldn't then get the supply from somewhere else. So whilst it is probably correct to say that you might have the company might have a damages claim, I think the greater risk is that if you purport to terminate, or you cease supplying items that the company needs, it might merit an application to the court for an injunction, either preventing you from, or for declaration to say that the termination was either ineffective, or compelling you to comply with your obligations to deliver, even if there are outstanding payments due for earlier supplies. It hasn't really been tested yet. We do know that in relation to some of the other, there are some restrictions in the Act about your ability to be able to present winding up petitions, and we do know that the courts have been enforcing those restrictions by the use of orders or mandatory injunctions preventing you from continuing with the petitions. But we haven't seen anything in relation to what happens on termination, and it may well be that we don't see anything for some time, but I think that's probably got to be a real risk here.
Okay, due to time, we'll finish up there, and we'll follow up separately with those of you that have asked questions that we didn't have time to get to. If you do have any further questions, then please do get in touch with Lino or I by email or by LinkedIn. You can use the QR codes that are on the screen there to connect with us on LinkedIn if you're not already connected to us. Also, if you have any topics that you'd like us to cover in this series of contract conversations, then please do get in touch and let us know. We would also be grateful if you could quickly fill in the two questions on this poll that one of my colleagues is just going to put up on the screen. There it is. Really value your feedback. It helps us make these sessions better. So we'd be really grateful if you could just take a minute to fill in this survey. Whilst you're doing that, the next contract conversation in this series will be in 2 weeks' time, on Tuesday, 10 November, at the same time, 3 p.m. And my colleagues Mark Davison and Sarah Jacobs will be hosting that one, and they'll be discussing the obligations on parties to act in good faith and what that means in the context of the pandemic. So that sounds like a really good one. We hope you can join us for that. That's all for today. Thank you very much for joining us. I hope you enjoyed it.